Welcome to our panel today. We have a great crew of experts here. Today's topic is the GDPR, Pain, Compliance, Problems, General Information. I'm Mike Starl, I'm the Vice President of eDiscovery and Digital Forensics at HaystackID. I deal a lot with large cross-border matters, large investigations. I'm really happy to have our group over here today. I just want to start to introduce everybody. Today we have Paul McGrady of Winston & Strawn. Paul's partner at the firm. He works with some of the largest brands in the world on adoption, prosecution, licensing, and enforcement of trademarks in the United States and throughout the world. He concentrates his practice on internet law. We're very excited to have him. We also have Martin Tully. He's a founding partner of Actuate Law in Chicago. He's a veteran trial lawyer, a lot of experience, very adept at eDiscovery and digital processes related to cross-border issues. We have also Dipali Dadi. She's an associate at Ice Miller. She has a background as a regulator with the U.S. Department of Health and Human Services. She also counsels clients on GDPR issues, privacy shield like mechanisms, cross-border data transfers. Really excited to have her. She has the perfect expertise for our panel today. We have Andrew Sodick as well from Secure Compliance Solutions. He's president of the firm. They're a cyber risk advisory and managed security firm serving the Chicagoland area. So, with that being said, we're going to start right away with Dipali over here. I have a good question for you. So the GDPR replaces prior EU Directive 95/46/EC on May 25th of 2018 with a robust new set of regulations. Can you tell us what EU Directive 95/46/EC was, called the Privacy Directive generally, what the new GDPR is, and what the major differences are between the Privacy Directive and the GDPR?
Sure, and thank you for having me on this panel. Happy to be here. And for starters, I think it's important as we're discussing GDPR to keep in mind that in Europe, privacy is viewed as a fundamental human right. And that idea is quite different from how we look at privacy so far in the US. And that concept drove the Parliament to issue or passed the EU Directive of 1995. And that was a set of data protection rules that each EU member state needed to interpret and then implement by passing national legislation. So the difference with the GDPR is that it's actually a regulation. It's immediately binding on all EU member states. And for the most part, EU member states don't need to pass additional legislation to implement what the GDPR requires. So the goal with the GDPR was to actually harmonize how Europe looks at data protection issues. All member states will have to comply with a singular set of regulations under the GDPR. And that wasn't the case with the directive where it was a set of guidelines on how to protect data, and then you had each EU member state coming up with its own interpretations of those guidelines, and you had different sets of rules in Italy versus Germany and the UK. Here with the GDPR, there's a single framework for data protection. So in many ways, that simplifies things. But on the other hand, the GDPR also imposes additional obligations that the directive didn't necessarily contain. And perhaps the most significant and important difference that many of you in this room are concerned with is that the GDPR has a broader territorial reach. US companies, for example, that never had to think about European privacy laws before, now need to think about European privacy laws. And I imagine that's part of the reason why you're interested in participating in this discussion today. So even if you don't have a physical establishment in the EU, you still might need to comply with GDPR if your company offers goods and services that target EU individuals. Also, if you monitor the behavior of individuals in the EU through, for example, your website employing behavioral tracking technology, that might be a way you're monitoring individuals in the EU and their behavior. So those are two ways that might trigger applicability of the GDPR to your company. And additionally, there are other areas in GDPR that are different from the EU directive. There are stronger requirements around individuals' rights. For example, not only the right to access data from an organization, but also the right to be forgotten, which is the right to request your data to be erased. And there are also some changes in terms of breach notification under the GDPR. In some cases, you might have only 72 hours to report a data breach to a regulator if you determine that reporting is appropriate in that instance.
Thank you very much. That was a good overview. I have another question here for Andy. So there's a fundamental difference between the United States and Europe as it relates to the definition of personal data and data privacy. Under GDPR, how is personal data generally defined, and how does that differ from what we understand personal data to be in the United States?
Okay, well, so the history of privacy law in European Union versus the US has been somewhat divergent. And where the United States has taken sort of a piecemeal approach where we have privacy laws that either target healthcare or target financial services, target the protection of children. The GDPR is an omnibus law. It protects all forms of privacy and personal data. When we think about, for instance, in PCI DSS, we look at financial information. We're really concerned only with personal identifiers that are external. Those would be your name, your social security number, your credit card information, et cetera, et cetera. With GDPR, we are looking at contextual information too. So not only is the personal data that we're interested in protecting those sort of external personal identifiers, but it's also things like your knowledge, your belief system, religious affiliation, sexual orientation, your geolocator information. Companies now have to figure out how to segregate those data elements so that unless that data is being processed for the purpose that's explicitly stated by the organization, you don't want to be able to identify the individuals. That will take some technical prowess to either encrypt or tokenize those personal identifiers and then segregate them so they can't be pieced together by those individuals who may be part of the organization but aren't supposed to have access to it.
Thank you. So Martin, you have represented clients in complex like litigation matters in a variety of industries. That being said, at a high level, what are the major components of GDPR and what type of organizations are most effective?
Sure, thanks. And first of all, thanks everyone for being here. Can everybody hear me in the back? All right, I usually never have a problem being heard, so I just thought I'd check. So GDPR consists of 99 articles and 173 recitals, and I've got 2 minutes to tell you what it's all about. And that's really important because you've only got 28 days before it goes into effect. So I'm going to do my best to kind of give you a real high-level overview of what GDPR requires. I'm going to break it down into 3 categories. 1, what organizations must do, what businesses must do. Number 1, must implement privacy by default and privacy by design. What does that mean? It means you have to be thinking about privacy when you launch a product, when you launch a process, when you undertake everything. You have to be thinking about the very things that Andy just talked about from day 1. And privacy by default means that the people whose data is involved here don't have to do something to keep it private. It's your obligation to keep it private from the outset. Number 2, organizations have to maintain appropriate data security, which is becoming a very important element even beyond GDPR these days. Number 2, timely notify data protection agencies and consumers of data breaches. 72 hours. No problem, right? Get appropriate consent for most personal data collection and provide notification of personal data processing activities. This goes to what Andy was just saying is you have to get consent to do something and then don't do something other than what you got the consent for. And don't say you're going to do something. Don't use the data for something other than what you state you're going to be doing it for. You can get in big trouble. Number 2, have to get parents' consent to collect data for children under 16. Did I just say number 2? I'm sorry, wherever I was at. Keep records of all processing of personal information. Appoint a data protection officer if you regularly process lots of data or particularly sensitive data. Next, take responsibility for security and processing activities for third-party vendors. This is where GDPR extends into people who don't have anything to do with Europe, but we'll come back to that later. Next, you have to conduct a data protection impact assessment. More on that later. Institute safeguards for cross-border data transfers, which may include things like binding corporate rules and things that we've heard about before. Next, consult with regulators before certain processing activities. Be able to demonstrate compliance with GDPR on demand. Again, no problem. And provide appropriate data protection training to personnel having permanent or regular access to personal data. That's what organizations have to do. What do individuals have rights to do under GDPR? A few things. 1, withdraw consent for processing whenever they want. Request a copy of all their data. Request the ability to move their data to a different organization and object to or opt out of automated decision-making process, including profiling such as, you bought this product, wouldn't you be interested in that product? Those kinds of things that we all engage in. And then what makes everybody really scared about GDPR is what can the regulators do? Well, they can ask for records of processing activities and proof of steps taken to comply with the GDPR, impose temporary data processing bans, require data breach notification, so even if you don't give the notice, the regulators might, or order the erasure of personal data. They can suspend cross-border data flows, and the thing that catches all the headlines is enforce penalties for non-compliance of up to 20 million euros, or 4% of your company's annual revenues for non-compliance. But again, nothing to worry about. It goes into effect in 28 days, and all this is very easy.
That's quite a framework. That's a lot of infrastructure. Thank you very much. The GDPR provides certain privacy rights to individuals who are considered data subjects. Broadly, what are those rights, Andy?
Well, he just sort of touched.
Yeah, I think we'll move on then.
Yeah.
Can I ask a follow-up question to that?
Sure.
So if you can withdraw your consent to processing, what keeps somebody from getting a loan from an EU bank and then withdrawing their consent for processing for collection purposes?
There's fulfillment of contract obligations, and also there is the consumer, the individual, still has the liability for the debt, and under GDPR, collections will be granted. You don't even have to go out and get consent necessarily from the consumer.
So it's not an absolute right.
It is not an absolute right, and that is one of the exception cases. So.
And to add to that, I think one of the misconceptions about GDPR is that for every processing activity you undertake, you need to obtain consumer consent. That's not the case. There are other bases under which you might be able to process EU data. One of them, as you just said, is if you're entering into a contract with an EU data subject, that's an exception to the rule to get consent. You can process data for the fulfillment of those contract terms. So we've had a lot of clients who are worried that they need to implement consent mechanisms for every type of data processing activity that they need to undertake. And that's not the case. There are other legal, lawful bases under which processing activities can happen. On the other hand, sensitive data, which we'll touch upon a little later, you actually do need consent in most instances to process sensitive data. That includes items such as health information, racial and ethnicity information, and et cetera.
Right, so the key is if consent is required, it can be withdrawn, and then you have to be able to deal with that.
Paul, what do you see as some of the most immediate impacts for just like companies operating in the United States, the EU, as it relates to GDPR? Obviously, it's a 100, list items, but what do you see as the really top ones that are going to change things right away?
So we talked a lot already about sort of inward facing. What do you do with your own data? How do you get ready for the regulation to come down? We've not really directly mentioned the fact that although there's a single EU regulation, each local data protection authority has the right to enforce. And so you could go get advice from Italy, but maybe Luxembourg doesn't like that outcome. So there's a lot of ambiguity when it comes to inward facing. And a little bit, I'm going to talk about some changes to how GDPR will affect all of us in basically keeping our data safe from breaches, right? We've heard about the 72-hour rule to report a breach. But guess what? The bad guys aren't going away. And the bad guys are going to be harder to find. We're going to talk about that a little bit. And so this is all sort of a circle. So inward facing we've talked about, outward facing we're going to talk about. The bottom line is it's going to get a whole lot more difficult at the end of May to protect your systems from incursion.
Thank you. Martin and Paul, Martin and Polly, what types of fines, can we get more into the fines that companies are going to face under GDPR, and just any type of problems that really haven't become clear yet that you guys see are going to bubble to the top as far as the framework is concerned?
Sure. So depending on the violation, your company might be subject to a fine of 4% of your annual global revenue. And those are for the more egregious instances of non-compliance, like not getting consent to process special categories of data when you need to, violating principles such as privacy by design. For lesser types of violations, like not having the proper records in order to demonstrate your compliance, or not notifying the regulator about a data breach that happened, your fine might be up to 2% of your global revenue. And there's been a lot of discussion on what happens on May 26th when the GDPR is fully in effect. What will the regulators do? And we don't have a clear answer on that. We're hoping that they will give companies some time to refine their GDPR programs after that point before they start hitting companies with fines, but that remains to be seen.
Can I ask a follow-up question? Sure. How does that process work? Can the regulators go out and just fine you on their own, or do they need an inbound complaint from an aggrieved person?
Yeah, and I think those are two ways that the regulator might be able to look at an organization's GDPR compliance, the complaint mechanism, as well as they notice from looking at your website that you don't have any GDPR compliant privacy notices. So I think both ways are avenues that the regulators could take. And so we've been advising some of our clients to prioritize the long task list for GDPR compliance by first looking at what are the externally facing documents, what are the documents that the regulators will see. Make sure you have your GDPR compliant privacy notice on your website, because that's something the regulator would see. And then at the same time, communicating notices to your customers is important so that they're less likely to maybe file a complaint that would catch the regulator's attention.
There's an important third way that a inbound complaint could come in, and that's self-reporting. Because the framework in GDPR actually goes way beyond, for the administrative fines, goes way beyond the time we have today. And the 4% of global turnover is what gets all the attention, but as DePauli said, there's a whole framework of what the regulators can do. They don't have to fine you. They can also reprimand you. And it's based on a whole set of different factors are laid out in the regulation, which sound an awful lot like whether somebody gets sanctioned under Rule 37E, quite frankly. Is it remediative measures? Is it curative measures? Is it punitive? It sort of depends on the nature of the breach. and any mitigating circumstances. So what have you done to try to correct it? Did you notify the regulators of it yourself and work with them? Was there cooperation? There's a whole bunch of factors that we don't have time to get into that'll weigh in on what the fine will look like or whether there's a fine at all.
So if you found yourself in the newspapers in the last 6 months because of your privacy activities, you better get ready.
Do you have a question, sir?
Prior violations are a big factor.
How significant will keeping personal data unprotected, meaning unencrypted or anonymized in your database, play a role in this whole process?
That they say that the regulators are saying that that's going to be one of the first things they're going to go after. If you don't have general cybersecurity controls in place, because those frameworks have been out for a while, ISO 27000 series or the NIST 853 or whatever. If you're not doing those basic things right, those are the first fines they're going to start implementing. So,
Just so that before we take the question, the other thing, just to make this even scarier, is on top of GDPR, the different entities in the EU can also add their own layer above and beyond GDPR, adding some additional restrictions and issues about how some of the things are to be done that factor into the fining as well. And obviously we have no idea what that's going to look like.
and now they're also talking about adding legislation to allow for class action civil lawsuits. So on top of all the fines, you know, there's the possibility that if you breach a whole bunch of people, you're going to get that civil lawsuit as well.
It's looking good for lawyers. Yes, sir.
Where's the domain of GDPR? Is it run out of Brussels, like a lot of EU initiatives, or where's its domain?
There's some of that, and there's some in Strasbourg as well.
Okay. On the personal privacy issues, is at least in the States, and some of that's changing. If you don't, you can do trending, you can do machine learning, you can get at behavioral activities, you can do all those things. And it's not illegal as long as you don't identify an individual or person. How's that going to fit there? I can look at trends, and I can look at buying patterns, and I can go in without violating that and look at your credit history. I can look at you're a hunter, so I can then push product to you, etc. Is that going to be addressed?
Okay,
here?
so profiling is one of the big reasons why GDPR exists at all. Okay, so the U.S., the difference in privacy laws in the U.S. and European Union, I mean, they view privacy as a human right. Okay, and in the United States, we're willing to sacrifice privacy for other interests, counterintelligence, and commercial reasons. And so, you know, if you take a look at the evolution of marketing and digital marketing, and the way that, you know, in the past, before sort of the digital age, you still tried to sort of figure out, you know, what magazines are people that buy Ford cars reading so that you know where to advertise and things like that. The advent of big data and voluntary giving up of our own personal data all over the internet has been something that marketers have been able to take advantage of. And they profile, and it's not a problem here. And in fact, just last year, you know, Trump ripped up this internet privacy rule that was established during the Obama era. I'm not going to get into the political issues of that, but you know, it is different, and so
Which is it right, or is it just different?
it's
That's a vital. It's not either or. I mean, I can do machine learning. I can look at impact studies. I can, you know, do targeted marketing without violating your privacy.
so the way that it is supposed to be done under GDPR is you pseudonymize the data. Okay, so you create tokens for those personal identifiers. You can do all sorts of demographic profiling, but you can't do it on specific individuals. You can't, you know, you can't exploit the individual's data that you've got. Personal data. But you do it at a
hunter.
yes.
Or I can target.
Okay, again, in context, I'm going to use this example. So if I go out and I buy a BMW, right? I mean, I'm just one 49-year-old guy having a midlife crisis, right, in Chicago. But if there's an old lady who goes out and buys a BMW M5 and lives in a very small town, it's very easy I may not know who that person is by the AI work that I've done, but I can easily drive around that small town and look to see whose driveway has that vehicle in it. And then I can identify who that person is. So context is key.
Thank you. We'll hold on questions for a minute. I want to jump now to basically talking about some of the new roles and responsibilities for organizations as it relates to handling personal data. The role of the data processor and the data controller is something we've been hearing about since the Privacy Directive, and it's central to GDPR. Can you guys tell me, Andy and DePauli, what are these roles? What do they mean?
Okay, so there are 3 roles that are identified for organizations under GDPR. The first is the Data Protection Officer, and that is the role, okay, this is a little funky. You hire the Data Protection Officer. The Data Protection Officer is accountable to the European Union, reports to management, but accountable to the European Union. Their role in your organization is to champion the GDPR requirements, to provide guidance around how to implement those requirements, to review data protection, data privacy impact assessments for compliance with the regulation in general. Okay, that's the first role. The controller is the second role. The controller is the role that authorizes the purposes for which you will process data. They will authorize the mechanisms that you use to process the data. They really are the data owner for the company, and they're accountable for everything. The processor is actually the role that processes the data for whatever purpose on behalf of the controller. The processor can be internal or it can be a vendor, a subcontractor. But the processor is always accountable to the controller. The controller is accountable to the European Union. The Data Protection Officer is the role that interfaces with European Union regulators. So when you look at that the data breach notification of 72 hours, the controller is who is supposed to report that to the European Union regulators. That means if you've got a vendor who is your processor, they need to let you know about their data breach shorter than the 72 hours of detection, because the controller has to report it within 72 hours of detection. So,
what is data processing? It's very different, right, than how we understand data processing and eDiscovery, for example. Can you talk about that a little bit?
Oh, sure. So data processing is a very broad concept. Processing refers to anything you do with personal data, including collecting, storing, modifying, transmitting it within your organization, outside of the organization. So basically anything you do that touches personal data is a processing activity. So it's important to keep in mind when we're talking about data processing, it's very broad. It includes simply collecting personal data. And to build off of what Andrew was saying, it's really important to understand whether your organization is a data controller, a data processor, or even both, because your GDPR compliance obligations depend on your status as a controller or as a processor. For example, a data processor might not be required to get consent from data subjects where it's necessary to do so. That would be something the data controller is responsible for. And the data processor is typically a vendor that provides services on behalf of a data controller. And further complicating matters, your organization might be both a controller and a processor. We've worked with clients who are data processors when they're interfacing with their customers. They're providing a software solution to their customers, and they're a data processor. Their customers are responsible for getting any consents that are necessary under GDPR from their clients. On the other hand, the same company might have a presence in Europe, and they might have European employees at those establishments in Europe. And so our client is then a data controller with respect to employee information. And so they are responsible for identifying whether at all, if at all, consent is appropriate with respect to processing employee information, identifying whether they have a lawful basis for processing employee information, interfacing with the regulator when they have to report a breach within 72 hours. So I would say that as a starting point, you really need to define and determine whether or not you fit within the data processor or the data controller category.
Thank you. I keep hearing, like privacy by design. Do you want to briefly talk about that, Andy?
Sure.
Okay, so privacy by design basically means that you are considering privacy at the very start of an initiative. Okay. So let's say that you're going to create a new service or a new product. Right at the very beginning, your requirements, when you're putting your project together, your requirements should include an assessment of privacy risks, either for the data subjects or the users of the solution, the service, the product. You continue to re-evaluate that. You conduct a data privacy impact assessment at the beginning of the project. You revise it and you re-review it during the design phase. You're going to do it again at the testing phase. Then you put it out into the wild. You're not done there. You still need to evaluate whether or not there were any privacy risks that you maybe didn't identify before. And then as you put out product enhancements, product or service enhancements, those should be addressing those privacy risks. This is really going to change the way that, from my perspective, working as a cybersecurity consultant, it's going to really change the way that we design cybersecurity, because we really are going to think about the privacy risks to data subjects in advance of designing a solution and then implementing it.
Thank you.
Can I just ask a follow-up question on that? Because security by design is also another word that we're hearing, and security and privacy aren't the same thing, but Andy, how do you see those two things becoming more interrelated? I think you've already touched upon it a little bit.
Yeah, I think, so with security by design, we're again, designing security in from the get-go. So if we think back to, here's a flaw that we've got in the cybersecurity world, right? Software development. Software, typically gets put out because of some function that we're trying to fill. And security is has been historically sort of a byproduct or an afterthought. And so then you get enhancements and updates. Those enhancements really are just buttoning up the security that should have been there in the first place. With privacy by design, now we are definitely not just looking at the security of that software and its availability or how it handles data in terms of the data accuracy that goes in and out of it. We're not concerned with just the protection of our company and our intellectual property. We're now concerned with the privacy of the users of the software.
Right, and
so,
even more so with all the Internet of Things, all the Internet connected devices are out there, a lot of which that are not designed to have updates or to last very long. They collect, in many more cases, all kinds of information. It certainly falls under the category of personal information from the European standpoint. You have all those devices that are out there that aren't designed to be secure. They're collecting arguably personal and private information. That's got to be something that's got to factor into this as well.
Think about internet-connected medical devices, where now it's a life and death situation, right? If a pacemaker, is hacked, it's got catastrophic implications. So,
Go ahead, sir.
Yeah, I'm listening to the legal sides. I'm from the technical side. This is something that this whole group in the world has to live with to make 28. Your example was great with the BMWs. Now you're a pharmaceutical and you're studying medications. Now you can't use a name associated with the drugs associated with if it worked or not. Now you have to make that email or that name into an encrypted value for the safety, the same way you're talking about doing with the car. That changes how they do it. The end result could be close to the same. That's the same thing that goes on for marketing. So now it becomes, do I worry about getting fined? Do I worry about a cure? Or do I go out of business because that fine will take me out of business? And from the technical side, you're also dealing with disparate data. I want to get heavy into that. You got Oracle, SQL Server, DB2 Teradata, and now you got big data. Okay, you got Hadoop, you got other stuff. If you don't centralize everything, you folks know what indirect identifiers are. If I ask this group, most people won't, and that's what you were talking about, that indirectly, by a certain illness, in a certain age, in a certain city, I can figure out who it is. You have to protect that information. Without putting everything together, how can you physically and scientifically do that? You can't. These are processes that are going to take companies months and years to do that they're just not aware of. You're talking legal, but when we really get down to the technical part, decryption, I call Walgreens. They say, what's your name? What's your birth year? How are they going to do that now when it's encrypted properly? They decrypt it, it sits in memory, it sits decrypted for a short period of time. Does it get re-encrypted properly, and does somebody steal it during that time? So I'm just bringing this up from the technical side versus the legal, and this is a huge gap of what everybody in this room and every major company is going through and guaranteed to fail.
Yeah, I mean, I don't disagree with you.
Yeah.
But I will say, look, you know, if you're processing a credit card, right? The person who enters that credit card into the system may just see the dots, right? Because it's hashed, and they'll never see it again. And yet, you can still figure out how to run analytics on the credit card, depending on whether you use the last 4 or the first 5, right? But you don't necessarily have to identify the individuals who are using that credit card if what you're doing is analytics, right? So same thing. I mean, I'm simplifying, of course, but you can run statistics on demographics with respect to the research you're doing on the pharmaceutical side. You just can't name the specific individual who's taking that med, and yeah, I mean it's a slippery slope, but I mean you gotta use your best judgment if you're doing the things that GDPR requires of you to do, and look at it like a framework, a privacy framework. A breach is gonna happen. It's not a matter of if, it's a matter of when. Okay, so what we're hearing is that regulators won't fine you 4% or $1.6 billion in the case of Facebook if you have been diligently following the framework. And I mean, hopefully, if you've been doing all the things that you should be doing, then smart guys like these HaystackID guys can come in and get to the information that they need to, because of course you've got backups, you've got all the trails that you're supposed to have to protect the data.
One other funny thing that you brought up, the EU, the IOC, and everybody, they don't even have a means, because you were asking how do they find somebody. Well, they don't even have the means today, or the technology, or a haystack, or somebody like me or somebody else to go in and audit. I've heard they use KPMG to do spreadsheets in Excel for 8 months. That's outdated the next minute. So without constant 24/7, 365, and a means to audit, they're only going to be able to go after people after the hackers say, we disclosed Uber's information, or a hack is told to by somebody. But my understanding today is they don't have the means to audit in a timely fashion. So is that even an option?
Well, okay, but can't you be, you should be self-auditing and self-testing, and you've got a data protection officer who's part of your company, but accountable to the EU, right? So they are, they should be sort of constantly monitoring your activities, right?
But you have no fear of the EU doing it because they can't.
Well, it's a
Self-reporting the requirement. Right?
yeah, and it ends up to be a big network of people who are, you know, tied to the European Union regulators that are going to do that sort of work. Now, listen, don't do it, okay? Just say no, okay? Don't try and comply with GDPR because for all the reasons that you've had. And what company do you work for? And why, you don't respect our privacy. So what company do you work for?
I have a software company.
Just kidding.
Thank you so much. I really wanted to dig in a little bit into the data protection officer. Martin, can you give us a little bit more of a look at their roles and just what that looks like and why that's such a new impactful job?
Sure.
Is it a C-level job? Or?
Well, that's a good question, and Andy already did a really good job of describing what a data protection officer should do, so I don't want to replow all the ground, so we can get to as much as we can. But obviously it has a number of different roles, that person has a number of different roles, as Andy's already mentioned, and it's something that's required, and even if it's not required technically under the regulation, probably a really good idea to have regardless. And whether you utilize somebody in that role anew, you actually hire somebody who's going to be your data protection officer, or you have someone else within your organization fulfill that role, whether it's your chief information security officer or somebody else within, chief compliance officer or someone else, it doesn't really matter. But you have to make sure that those roles are fulfilled. But it's really going to be, Andy's already described what the obligations are within an organization, and it's going to be similar, I think, to the CISO role, which is figuring out, do you have somebody already on staff doing it? Do you outsource it, for example? How do you achieve essentially the objectives of the regulation within your means? Because there is behind all this concept of proportionality. We know about that. That's something familiar to us. What's your risk profile? What are your obligations? What is the cost? And what is the realistic way for you to do it? And I think, as this panel's already said, the regulators are going to be looking for people who are trying to achieve the end result. Perfection is not required here. Reasonableness is.
Are you self-reporting to a local DPA, or is that now changed? No, under the privacy directive, there was really stratified. You'd have a guy in Germany, you'd have different, even on a state level, you had different data protection authorities. Has that now moved up, or are those same bodies still relevant? Are they being integrated into the wider GDPR framework?
Right, so if your company only has an establishment in one EU member state,
Sure.
You're reporting to the regulator in that state.
Got it.
But if your company has locations in several EU member nations, then there's something in the GDPR called the one-stop shop rule, which allows you to effectively select which will be the main regulator you're going to be interfacing with. For example, if you have locations in Italy, Spain, and the UK, you would have to do some analysis to figure out which is the appropriate regulator that will serve as the single point of contact when a breach occurs, for example.
Okay.
But there is some analysis required to determine which regulator you select.
Got it.
Follow-up question on
Yes.
that. Does your designation of that regulator keep the other data protection authorities from coming after you? So if I designate Italy, will that keep Netherlands from coming after me?
Right, there is a provision in the GDPR that addresses cooperation among the regulators. And I think in this sort of situation, I believe so. Not 100% sure, but I think that cooperation requirement would result in one regulator initiating whatever enforcement action that might result without the other regulators also taking additional enforcement actions on top of that.
And is it 4% total, or does everybody get 4%?
Yeah, that's a good question. How the penalty will be allocated amongst various regulators. I don't think there's an understanding that's that has been reached as of today.
So if you're going to pick a place, you're going to pick the richest country that doesn't need as much money for their budget.
Right. Well, there has been commentary.
You're not going to go to Greece or Spain.
There has been some commentary put out by the regulators that discourages forum shopping. So we would have to keep that in mind. You don't want to forum shop based on considerations like that.
But the UK ICO basically says, this is how we're funding our ongoing, staying in business, right? Is through the fines.
And it's not 4% just once a year, and I think some people get that misconception. If you violate it vaguely 10 times, that's 4% 10 times for the same exact amount you made last year.
Or 20 billion euros, whichever is greater.
Yes.
Yeah.
So for US-based like companies doing business in Europe, and this is from Martin and Paul, how are they going to be affected by GDPR really right away, and how can they prepare for compliance?
I've been talking way too much. This is all Paul.
Light your hair on fire, run down the street screaming GDPR. It's too late, really. I mean, at this point, if you don't have a plan that you're executing Thursday, well, today's Friday, so yeah, 4 days. It's too late to be compliant, I think. A lot of companies came to this late. I'm going to talk a little bit about ICANN. Does everybody know what ICANN is? We're going to talk about who is, right? They seem to have come to this in September, and they have, they're essentially sitting on personal information for millions and millions and millions of people. They've been asking the EU for a forbearance period of 1 year to become compliant, and they're getting nowhere with that ask. So I mean, it's upon you. So if you have not started down the path, you're behind the 8 ball. Hopefully you're less exciting than other people that have been in the newspapers recently with regard to their privacy behavior. So you might get ignored for a while just because you're a softer target. But I wouldn't become compliant and decide you're going to be a soft target forever. Because once the first big company or the first 50 big companies are sued and they're turning over 4% per violation and they're finding multiple violations, eventually those big companies are going to figure it out and they're going to move themselves off the target. But by that point, the EU being the EU, and I will get a bit into politics a smidge, since they're the ones causing all this, by that point they will have built out a giant bureaucracy to enforce this in each of the member states, and it will be a hungry bureaucracy, and the only thing that feeds bureaucracy is what? Money, right? So they're not going away. So just because you may not be Twitter today in this room, that doesn't mean that you're going to be off the hook. So if you've not started this, you need to start it right now.
According to NetApp's recent study, 12-page study of C-level people, and a real good one of 1,300 people, 75% minimum of all companies are not going to be compliant, and half haven't even started. My prediction is 95%. The 5% that say they're ready would fail anyways. So just to go along with you, it is real danger.
Paul, what type of technology tools can be employed to help with compliance?
So I'm not going to answer that question. I'm going to answer the question I want to answer instead.
Sure.
No politics at all.
So I'm going to talk to you guys about a real live use case. How many people in the room have a website? Let's start. Let's all put our hands up. All right. How many people in the room have a website at their company? Put your hand down. Okay. How many people with their hands still up? Please keep them up. Okay. How many people have children who use the internet? Put your hand down. How many people in the room have parents that use the internet? Put your hand down. So we're trying a process of elimination. Yeah. So just Lee Neubecker is essentially the only person living in a cage because his hand just finally went. All right. The bottom line is that this applies to all of us, right? So I'm going to tell you a story about a company called ICANN. ICANN is the Internet Corporation for Assigned Names and Numbers. It is a nonprofit in California. Some people have heard of it, some people haven't heard of it. Historically, it was under the regulation or the control of the U.S. government. The Obama administration gave that away 2 Octobers ago. It is now a standalone nonprofit in California. They control the domain name system and the numbering system. So every one of you that has a website, every one of you that uses email, everybody that connects a device to the internet are either getting a domain name or a number from these people. Okay, so they're central authority on the technology side. Now, how many of you are responsible to make sure that your systems don't get hacked and that your data doesn't get carted away, so that you have 48 hours to tell your new data officer, so he can make a 72-hour deadline that there's been a breach? Raise your hand if anybody in the room is worried about their data not being hacked, right? I think most of us worry about our data being hacked, and if we're not worrying about that, we probably should. One of the first responses that you can do is to track back IP addresses and then run whois searches on the IP address to see who the hosts are or who the bad guys are. If they're foolish enough to have their own domain name, you can find out who is that domain name owner. When it comes to phishing and fraud attacks against grandma, when it comes to counterfeiting of auto parts or airplane parts, all these things, we use the whois system all the time to get the information about who the bad guys are, to do reverse registrant searches to see if we can develop patterns of who these bad guys are. We look at hosting information to see if we can determine how many bad guys are out there, how many pools of bad guys there are, right? So that we can refer it to law enforcement, so that we can sue people, so that we can go to hosts for help, so that we can go to registries and registrars for takedowns. Those are all things that we use the whois database for. Guess what? Going dark, May 25th. Because ICANN started their compliance efforts last September. They're not anywhere near the contracted parties, the registries and registrars that sell domain names. They're not going to take the 4% risk for any of us, right?
They only have 50 employees, and they actually put out a survey saying, we'll take the best idea anybody can give us and see if we can get compliant. That's how desperate they are.
Yeah, and so they've put forward various models for compliance that the registries and registrars are not completely comfortable with. They've been talking to the EU about compliance. But I just want to less focus on ICANN's problem, because they've got the same problem. They're a California company, but with data from all over the place. I want to talk about our problem, which is essentially, in just a few days, those of you who want to be able to track down the bad guys that are trying to get to your data, they're trying to rip off your customers, it's going to be a whole lot harder to do that. One of the questions we talked about, and I'm sorry I'm taking up too much time, one of the questions that we talked about is how is this going to change, or that's on our list, how is this going to change litigation and discovery? Guess what? There's going to be a lot more litigation and discovery. Because if I've got 72 hours, right, to go tell, I was smart, I went to Luxembourg, not Spain, right? I got 72 hours to go tell Luxembourg what happened, right, and hope for the best. I need to find out that information quickly, like not only what data was taken, but who the bad guys are and what we're doing about it to keep it from happening. Because it might happen the next day again, and the next day, and next day if I don't figure out who those bad guys are and shut them down. So guess what? People are going to go to court. They're going to be going and asking judges for emergency orders to get a hold of escrow data from ICANN and from the registries and the registrars, because if we can't get access to it the old-fashioned way by typing stuff in and looking at it, we're going to find a way to get to it. So, and that's just for the emergencies. For general garden variety litigation, if you want to find out, you want to find out almost anything about your opponent, you're going to have to go to court. You're going to have to ask for subpoena power.
But that order will exempt you from GDPR.
Well, I don't think so. I think
from what I understand and read, the legal system and the court order would for that.
Well, maybe our crowd can answer that, but maybe I think.
Right? I was looking at the lawyer up there just to ask her if you happen to know that.
Yeah. And so that's where we're heading, right? So it's going to become more expensive, it's going to be slower, and it's a real problem. For anybody in the room that's worried about data security, it's a real problem. And that's just one real-life example. Imagine that example across multiple industries as people figure out how hard it's going to be to get a hold of information they need to do their jobs.
Paul, is ICANN going to come back at some point, or are they just going dark, or are they really trying to get compliant? What's the time frame for them?
So I think they're going to... as far as we can tell, their plan is to go dark on May 25th. There is a push within the community of people who participate in the ICANN policy model to try to have some access to this whois data. And they're talking about a tiered access process where people can access it, but you have to be accredited to access it. Of course, we started 4 years ago trying to credit privacy and proxy servers, and we don't have that done yet. And so the blackout will not go away in the next year, 2, 3, who knows how long it's going to take.
I offer them free software and time, and they're just too messed up to even to have accepted and figured things out.
So it's going to be dark for a long time. So for those of you who are used to being able to get a hold of information quickly, shutting down websites, all that stuff, you're going to be spending a lot more time in court.
Better call Paul, I get to that point. Very good, thank you so much for that. Cross-border data transfer, right, is a big thing we deal with in the United States as it relates to litigation, right? We're asking questions about, am I compliant, like with the EU? We had in October of 2015, the EU-US safe harbor that collapsed. That was replaced now with Privacy Shield. Can you tell us a little bit about that, Paul, very quickly?
Yes, and as you said, cross-border transfers of data is a component of GDPR. So if you haven't already figured out how you're going to sufficiently transfer your EU data to the US for whatever purpose, you need to do so in order to be compliant with the GDPR, because there are provisions in the regulation addressing cross-border transfers of personal data. And you might be familiar with the safe harbor framework. And as a general rule, you also might know that the EU doesn't support cross-border transfers of data, personal data, to third countries that are not deemed adequate, that do not have adequate data protection laws in the eyes of the European Commission. The EU Commission has a list of countries that have practices that have been deemed adequate. The US is not on that adequacy list. So Safe Harbor came around as a way to implement a framework where EU data could be transferred to the US and meet the standard of adequacy. And Safe Harbor, as you said, was recently invalidated, in part because an Austrian law student by the name of Max Schrems challenged the adequacy of the framework. He believed that when Facebook was transferring personal data from the EU to the US, that EU data was susceptible to government surveillance within the United States. And this went all the way up to the European Court of Justice, and the European Court of Justice agreed with Schrems and invalidated the Safe Harbor framework. So in 2016, Privacy Shield came along as a replacement for Safe Harbor. And there are a couple of differences between Privacy Shield and Safe Harbor. A couple of differences are that vendor contracts are looked at more stringently. You really have to evaluate which vendor contracts that you need to amend to conform with the Privacy Shield principles. There are also additional requirements around data subjects, access to the information that a company has about you. You need to have in place an independent dispute resolution mechanism. There's a whole laundry list of what is entailed in Privacy Shield. The important thing to realize is that Privacy Shield as a basis for transferring EU data to the US might not apply to everyone. It might not be the best solution for your business. For example, not-for-profits are not eligible for Privacy Shield because they are not subject to enforcement by the Federal Trade Commission. So there are other avenues to support cross-border transfers of data, such as entering into data processing agreements that incorporate what are known as standard contractual clauses that the European Commission has blessed. We work with a lot of clients in developing those data transfer agreements. So Privacy Shield is one option. If you choose to go that route, you need to get your organization compliant with the Privacy Shield principles and then self-certify through the Department of Commerce. I will say though that if you are Privacy Shield compliant, you have done some of the legwork for getting GDPR compliant. There is some overlap between what the GDPR requires and what is required under the Privacy Shield.
Thank you. So on that note then, we just talked about transferring data across the Atlantic under the auspices of Privacy Shield, but what impact might GDPR have on the conduct of civil discovery in the US? And that's for Martin and Paul.
Well, Paul's already pointed out there's going to be a lot more of it, so we can look forward to that. But two things real quickly. Number one, obviously you've got a framework that has to be kept in mind when, for example, a U.S. company that's been sued and data from one of its European affiliates is involved in the case, and I won't get into the whole Microsoft case that's up before the Supreme Court about those issues, but this is now another consideration has to take into account on whether or not the information that is elsewhere is going to get caught up in a U.S.-based lawsuit for a company that is here but has an affiliate in Europe, or vice versa. A company that's based in Europe and has an affiliate in the United States, and if the data is deemed to be relevant that is in Europe, how is it going to come into play in the litigation, and is it going to be discoverable in the first place? Obviously, that goes way beyond the time we have today. But the other issue to keep in mind is something that goes broader than GDPR, which is the growing concern in civil litigation about privacy and security generally. And is there a basis to say that I am not going to produce documents or electronically stored information to you in civil litigation because I'm a controller or I'm a processor, I've got all these obligations, and I sure don't want to get spanked with a 4% fine. I've got to turn this stuff over to you. Who the heck are you, Mr. Requesting Party? What security maturity do you have? Do you have any security maturity? Are you using an expert that is Bob's bait and tackle and forensic examination shop? This is becoming a growing issue in the bench and bar right now as to whether or not there is going to have to be some requirement that a requesting party demonstrate some modicum of reasonable security maturity and the ability to maintain privacy of this information if it is compelled to be produced in civil litigation. So more on that to come.
So what you're saying is Word documents, PDFs, spreadsheets are all under GDPR regulation also. The data in them, emails, everything.
Sure. Absolutely.
Can I just do a quick follow-on to
Yes,
this?
please do.
So, but let's give a real-world example. I've got a real good buddy. He runs one of the biggest hosting companies in Ireland, and he's always fond of telling us that he will never comply with a U.S. court order. He will only comply with an Irish court order, right? Even though his business touches the U.S. in 100 million different ways, right? So, whether or not he is able to make that argument that you don't have data maturity, security maturity, that's not free, right? That's not something that the judge is just going to do on his own here in the U.S., right? So that guy who thinks he's never going to have to respond to a U.S. subpoena ever is going to have to come over here and make those arguments, and he may have to make them all the way up, right? In order to get some instructions to lawyers about that specific issue. And God bless him if he just digs in and says, I won't comply with the court's order to turn over this information. I wouldn't want to be on the opposite side of the federal judge on that issue.
Gentleman in the back.
Just to add a wrinkle to the Max Schrems and Privacy Shield, 2 weeks ago today, the Irish court ruled in favor.
The Facebook case by Max Schrems never went away, and so he was challenging some behaviors and practices of Facebook. The Irish court said yes, there's extreme surveillance in the United States. They referred 11 questions up to the ECJ. One of those is, again, whether the Privacy Shield is a proper and appropriate remedy. And so the likelihood, if you were a betting person, would be that the Privacy Shield is going to come down soon. And then to this whole Irish question, so that Supreme Court case was mooted. It was remanded and dismissed because the Cloud Act was part of the Omnibus Budget Act 2 weeks ago, or March 23rd, includes addressing issues of servers by Microsoft and others over in the EU, and the Irish objected to that as well. So I think more to come on that. But there's also a second provision in the Cloud Act that talks about the Attorney General can go overseas and by executive agreement do some surveillance and other things without court order, without court intervention. So more to come on all these things, I think.
I think so, and I think the way that we're helping all of our clients who are dealing with these issues is we have data centers around the world. So we have data centers in Canada now, we have data centers in Germany, we have data centers in the UK, we have data centers in China. And it's getting very difficult. There's a lot of redactions going on as far as removing like personal data. So I think just on the effects of civil discovery, it's really centralizing operations in the locale where an incident is happening, which I'm sure you're all going to experience.
Michael, we've got about 7 minutes
7
left and a
minutes,
few
okay.
questions here. If you want to pose a question, would you please stand up?
Please stand up.
Thank you. I have a couple of questions, please. One, is the UK a part of this? And if they are right now, what happens after Brexit? Second is, what happens if someone holds a dual citizenship, French and US? And let's say they're, which one takes precedence? And if there's a US citizen in France and they open an account in a bank, in an American bank, is that person, where does that data protection fall? And I'll keep that.
So I can address the second question first. So there is a misconception that GDPR applies to EU individuals who are citizens. That isn't entirely accurate. GDPR applies to personal data of EU individuals who are, meaning individuals who are in Europe, physically located in Europe. So it isn't based on an individual's citizenship. So for example, if an EU citizen were to receive services while he's visiting the US, the GDPR would not apply. That person's data would not be within the scope. But if a US business is collecting data from an EU individual while he's physically located in Spain, for example, then his data might fall under the purview of GDPR. I'm a US citizen, but if I visited Italy on vacation and Italy-based companies collected my data, even my personal data would fall within the purview of the GDPR. So that's an important nuance that I'm finding that a lot of our clients are struggling with. It really matters, what matters is where you are physically located. And citizenship isn't really, it's not an issue that comes into play.
Can you clarify that, though? If I went to Italy, because I wanted to do something and make a point, and I wanted to make a point to something on Facebook, can I go to Italy as a U.S. citizen, write something on my Facebook, which I've deactivated, and then be able to utilize that in order for me to go after them and have the same rights as if I were an EU citizen?
Yeah, theoretically, Facebook would need to treat your data that you're giving them while you're in Europe as EU personal data under the GDPR, even if you're just vacationing in Europe.
Hopefully those tracking cookies are getting updated geolocation-wise.
And then to answer your question regarding the UK and Brexit, it's my understanding that the UK is working on a data protection legislation that pretty much mirrors the GDPR requirements. So even after Brexit occurs, GDPR standards will apply to the UK.
Thank you.
Can I just add one more
Sure.
thing to that too? Again, context may be key here. So that French person that comes over here, comes to Chicago, and then while here, books a flight from his or her phone, okay? That phone is gonna eventually get back to the European Union, so while the data that is processed while that person is here is not subject to GDPR, the fact that it came from a device that's registered in France may also add some hair to it.
Any other questions? Please stand up. Oh, hello.
I'm standing up. Okay, so it's a lot of details, but I just have to throw it out because it's the world I live in. So I'm in Italy. I'm visiting. I see this come through on my phone that there's this great offer from Capital One. So I log into Capital One's account on my phone, and it's a new credit card. So I open a new credit card on my phone while I'm in Italy. Is that GDPR?
Again, I think it's also going to be a matter of context, okay? So, you know, you sign up for that credit card, but you're going to come back. You are a resident of the U.S., okay? They're probably not going to send a bunch of additional marketing to you while you're there, but, I mean, all bets are off once you come back, so.
Understand, to take it to another level, I know we've only got minutes. Okay, so let's say that I don't. Let's say that I'm actually working in Italy and I'm going to stay in Italy, but I still open that card and I decide that Italy's not paying me enough money, so I'm not going to pay that credit card bill. It gets reported and charged off and it gets sold to a debt buyer. The debt buyer reports it to Equifax. Equifax gets breached again.
So I'm actually, I'll tell you, I'm in the process of doing some research around collections and debt buying.
Right.
So with the collection arrangement, again, you have an obligation to pay that debt, and so the collector can process your data. Once that debt is purchased by a debt buyer, I'm not sure that that's necessarily the same case. You don't have an obligation to that debt buyer. That debt buyer hasn't gotten your consent. So, as I said, I'm in the process of doing some research on that to try and figure that out. I don't know if there's been enough guidance on that.
Well, I would love to talk to you about that because that's what I do.
Okay.
So please, I will give you my card because I need more information.
Let's
That's why I'm
talk
here
afterwards.
today.
Okay.
Thank you very much.
And that's,
We're actually at our time, but we have the room for another 15 minutes or so. So people feel free to network. There's a great room of people with common contacts. I did want to point out, we have our chairman here, Mike Bryant. Back, raise your hand. Haystack. Eric Singer, our executive vice president, and Paul Jensen, one of our account managers. Mike, back to you.
Mike Sarlo is here as well.
And thank you, all of you, for
Yes, I wanted to just thank everybody for coming. We could all give our panelists a big round of applause. Excellent group.
Is this going to be on YouTube or available? Because I think this has been the most impressive.
I don't consent to that.
Panel.
Only in Europe.
You folks were amazing, and I think people can gain from this. Forget what your business would gain. This was a great panel.
And Haystack will be hosting a bi-monthly series of topics as well, ranging from GDPR to digital forensics issues and all sorts of fun. So we'll add you all to our mailing list, and we hope you all join us again. Thank you very much, guys.